2, 1. You have 5 seconds.
Good afternoon, ladies and gentlemen. Welcome to ALN House. My name is Karim Anjarwalla. I'm delighted to have you all here. On behalf of the ALN Academy, we are especially privileged to host Professor Githu Muigai, first and foremost a friend and a leading architect of constitutional change in our country. I don't think Professor Muigai needs much introduction, but I'll just highlight a few key points which I think are especially interesting. Apart from his academic pursuits, he was also involved as a commissioner in the Constitution of Kenya Review Commission between 2000 and 2005, and of course was our Attorney General in the seminal period, August 2011 through to March 2018. Those of you who follow our constitutional history closely will know that I think it was the 26th of August 2010 when we enacted the new, or not so new now, 12-year-old Kenyan Constitution. And really, it was a year later that Professor Muigai, as Attorney General, had to really shepherd in that Constitution and make it a reality. The book that he's written, Power, Politics and Law, which is what has convened us all here today, is very important because it traces the dynamics of our Constitution from well pre-independence, in fact from the start of the British involvement in Kenya, right through to the BBI process. It is a compelling read. It's available outside, and we are also very grateful to Kabarak University Press who published it. I don't want to take too much time because we're going to have a fascinating hour of discussion. But there is one point I want to highlight. You will notice, if you haven't already got the book, that the foreword is written by retired Chief Justice William Mutunga, who has also made vital contributions to our social fabric. And of course, in many senses, Professor Muigai and Chief Justice Mutunga are not exactly ideological bedmates, right? They look at the world differently, right? But the fact that they worked so cooperatively together in common cause teaches us a lot about how people with different ideological interests can nonetheless cooperate in a common cause. And I think there's a lot to be taken from all of us in that regard. Without much further ado, it's an honor for me to invite Professor Ambani, the Dean of the Kabarak Law School, who has published this book and with whom we are co-hosting this event, to say a few words. Professor Ambani, welcome.
Thank you very much, Karim, for hosting us here. Such a wonderful facility. When I grow up, and work here. Yeah, and the editor-in-chief, Kabarak University Press, Mr. Humphrey Sipala, has asked me to display a marketer.
As will I.
Yeah, there's many books they are doing, which are great. One of them being the one we shall speak about by Professor Githu Muigai. This one is the inaugural lecture given by Dr. William Mutunga when he became a professor at Kabarak University. It's the only, I think it's the only the third inaugural lecture given in this republic by professors. I believe the first one would be Professor J.B. Ojwang, the second one, Professor Kameri Mbote, and the third one by Professor William Mutunga. I'm sure you can sample a few outside. My commission is ready now. Yeah, I believe it's a light day, so it won't be a lot of formalities. But today I was thinking about a very prominent Western politician that is also talked about in this book, and that is Martin Shikuku. I remember that when we were younger, we would attend rallies with sticks, you know, and the sticks would match the number of points he has to make that day, you know. And when you see 5, you know he's speaking 5 points. And after every point, you throw the stick in the crowds and ask audience to return the stick if he's lying. The stick never came back. So a lawyer legend had it that they used to disappear somewhere between the air and himself. Anyway, I don't have the mistake. There's a similar mistake, but I think I've around 3 points to talk about here today, and then I'll repeat it. First one, I think, is to honor our leaders here, our seniors, Professor Githu Muigai, and senior here, Karim Anjarwalla, for the great work they have done to the legal profession. And there are very many things in common. Speak about them easily. One of them is that both of them founded great law firms that are worth emulating. And the law firms have mentored and brought up many professionals in this country. The second is that they are actually public interested, ready to help the public do something. Already Karim has mentioned some of the things Professor Githu Muigai has done, and Karim himself through the ALN has done a lot of things. Some of them we are witnessing today. But most importantly, they are very great teachers and mentors, and they are always ready to share what they have. I believe that is really the center of this activity today. So in my view, they are our own version of legal Sadhgurus. So we learn under their feet, and I will soon take my respective place there as soon as I'm done. Second point was to support these initiatives that ANK and ALN have been doing, and to say that Kabarak University is here to support that. And I'm happy that other universities as well have joined this. In that regard, I'm actually also saluting the university students here and the university colleagues here from, I'm told, different universities. You can hear me though? Yeah, different universities in the Republic. Okay, yeah. Just to salute all of us for supporting what ALN is doing. Okay, I think I can go now. Yeah, I think I'd made the point that the second point to just support what is happening here. You see a very good legal professionals coming out to assist young people, to assist the public, learn and become better than themselves. And this kind of session, I think, are the kind of things we want to encourage. The Kabarak Law School, we are fully behind it. To support the very theme of the subject today, the very theme of the meeting today, which is the rule of law and democracy. I've always spoken to young lawyers and told them that the law can only thrive where there is the rule of law. In fact, the rule of law is a condition precedent to your profession. The only other people that can thrive outside the rule of law are the soldiers, isn't it? The armed guys, the ones who are dangerously armed. They're the ones who survived in the jungle. And so if we want to have a livelihood as lawyers, I think we must ensure that first and foremost is the rule of law. So the soldiers go to the barracks, or the hooligans go to wherever dens they come from, and then we can, lay down law and order, activities like law, like a constitution, like courts, like organized dispute resolution mechanisms. And I think that's why we are here today. So that would be my concluding point. But as I say that, I encourage you to learn from our very best. I don't think you have a better place to learn than here. And soon, or immediately, I'm also going to take my respective seats at the feet of the great people, take my lessons. Thank you very much.
Straight into it. The one point I would make is that we're going to encourage questions during the course of the discussion. So if you do have a question and you think it's relevant to what we're discussing, please put your hand up and a mic will come around to you, and we will have some time for questions at the end. We also have a large online audience, so we may be getting some questions on online platforms. Professor Muigai has a teaching commitment, and so must leave here at 5 p.m. So we'll finish before that. We may have a few minutes for him to do some book signings, and then he will have to disappear. to make his teaching commitment later on this afternoon. So, Prof, to jump straight into it, and this is a direct quote from the book. You say it's puzzling that power is one of the most central concepts, yet it is at the same time one of the most neglected variables in African constitutional studies. It is still a useful metaphor to denote constitutions as power maps. Now, one of the themes I picked up from your book was how the overhang of the administrative state from colonial times still manifests itself, more than 100 years later in Kenya today. It was interesting to me to sort of learn that, in fact, the process of constitution making in Kenya did not begin with the fight for our independence, but in fact for the fight of independence of colonial settlers from London, right? Hearkening the Bostonian call about no taxation without representation. And then it got enhanced as the Indians began to now start to ventilate. And what was fascinating to me was that it was the recognitions of the rights of Indians, no doubt because of what had happened in India itself, that then opened the door to the recognition of African interests, which of course didn't happen in other places in Africa where there was British colonialism. So, could you just address that issue, the overhang of the administrative state, and how that original seeds of constitutionalism began to germinate in Kenya? Over to you, Prof.
Thank you very much, Karim, for inviting me here, and for the Academy, for my public. Is here Professor Ambani, who encouraged me very much in writing this book. One of my students who became better than the teacher. Thank you so much. Now, I want to start by picking up where Karim left. There are several themes in the constitutional history of this country that are sometimes lost to the casual reader of our past. First and foremost is how fundamental race and ethnicity were in molding this country. Today, it is easy for people to say casually, including in the journalism set, that tribalism, a very difficult word for me, it seems to me that from a sociological point of view, tribes must be people who live pre-fire and pre the Stone Age, jumping from tree to tree. But be that as it may, we read that tribes in Kenya are the glue that ties politics together. I think that's a very superficial analysis of this problem. The very foundation of the country we call Kenya today was essentially driven by race, by ethnicity. And if you look at something that is very, very clear, the districts that the colonial state generated, they were ethnically homogeneous, largely. So that there was Machakos, there was Kiambu, there was Narok, and they were all meant to contain ethnicities within them. And that's an important point, and it informs the constitutional struggle. From then till now, going forward, we went to Bomas, we tried to create only 11 counties. We succeeded. The politicians came and uprooted it. They said, no, we want counties that address ethnicities, and we therefore want to go back to colonial districts, and so on and so forth. And I'll come back to that theme later. The second thing that you will note is that the colonial state is an administrative state. That is to say, from the top to the bottom, nobody is elected to man the state. The governor is not elected by anybody. When you read the book, you will find the fights that go into the legislature, the legico. The legico manifests itself in the struggles between the civil servants because the state was being run by the civil servants. That's the governor, that is the provincial commissioner, the district commissioner, the DO, the chief, and the sub-chief. Their overarching control of the state is replicated today. When we made the Constitution 2010, we then spent 2 years in Parliament. It was my privilege to be in Parliament at the time, fighting to make sense of how we could run a democratic state, not only from the center, but at the bottom. And there were talks in those days of abolishing the chiefs and the chief system and the district commissioner and the DOs and so on. And we lost that argument, and the compromise was to rename them. They become regional commissioners, regional sub-commissioner, but the overarching dominance of the administrative state is very, very present. The reason being, and we'll come to that maybe later on, it is because of the weakness of the political culture, the democratic political culture, okay? And that is a work in progress. And therefore, if you think of various parts of this country without the presence of, quote, quote, the provincial administration, you can think of places that would be thoroughly lawless. And therefore, there is this tension, has been this tension, and I think Karim alluded to it. Part of the problem is that our state is created with absolute arbitrariness, where the boundary is drawn by the Berlin Conference and the aftermath is totally arbitrary. So much so that well, maybe not quite half, a quarter of the Somali nation is in Kenya. Another quarter is in Somalia. Another quarter is in Ethiopia. Those are too many quarters. Half the Maasai nation is in Kenya. The other half is in Tanzania. And you could go on and on forever. I think the best example is the people of Funyula. At one time, we had a vice president in Kenya who came from the same family, not distant cousin, immediate cousin, with a minister, a very high minister in the Ugandan government. It shows the randomness of the divisions that created the state. And that's why I make the argument that Kenya is a state, because a state is a legal entity. It is defined to be so. You've done that in your international law. It is a state in charge of nationhood. So there are several, in my opinion, there are several fissures, there are several cleavages that create an inherent instability in the constitutional governance of Kenya. That is, the place of ethnicity, the place of religion, the place of several other features, including the challenge between pastoralists and farmers. And it's right across the Sahel. You see it in Nigeria, you see it all over the place. And this creates instabilities in the political culture. I don't know whether I've answered that, Karim.
That was a wonderful introduction, Prof. I want to pick up this theme before I turn it back to Aisha about the transition from state to nationhood, right? Evidently, in 1963, we were simply a state, as you say, arbitrarily drawn by those who were in charge of the administrative functions of our government. And so the question I have for you is, a nation is different because it is built on some shared myths. I think that's the best way, I think, to describe a nation. It's a group of people who have some sense of common identity, belief, whether those identities and beliefs or historical allusions are true almost doesn't matter. So, for example, the Italians of today are in fact not the genealogical descendants of the Romans, but they believe that they are. And that's sufficient to create a sense of nationhood for them. What role, Prof, do you see the bare bones of a constitutional process? What role do you think it has in this transition from state to nationhood? And have you seen evidence of, improved evidence of us along that journey, say over the last 15 or 20 years?
Yes, I think that the difference between constitutional government in former colonial states is that, as we've said, the constitution is hoisted upon different ethnicities, different religions, different cultures, and out of them, the constitution is supposed to create a nation. That is contrary to history's experience. History's experience is that constitutions survive and have strong roots where they are natural outputs of the socio-political processes in those societies. If you look at the French, they first fight. They fight, they resolve who it is to be a French person. Then they write a constitution that says that. They don't go and borrow a constitution from somewhere, hoist it upon themselves, then wait to become a nation. And that's the challenge all over this continent and all over societies where there has been colonial rule. Look at India, look at Pakistan, look at Zimbabwe, Nigeria, look at Jamaica, Barbados. By the way, as a matter of interest, the constitution that was drafted in Whitehall to decolonize the empire was the same. It was the same constitution. And therefore, if you go to Jamaica or to Barbados or to Ghana or to wherever, except people who in the last 20 years have tried to write a new one, it is the same.
I'm sorry, Prof, but you know, as a commercial lawyer, I do believe in precedent.
Now, the challenge with that in the real world where people live is that, for example, a notion beloved to lawyers, the independence of the judiciary, the autonomy and neutrality of the civil service. 70 years after colonial rule, by the time we are becoming independent, there has never, ever been a civil servant in Kenya who was independent of the politics. So the Constitution is asking Kenyans to do something that has absolutely no basis. The Constitution is saying there shall be an independent judiciary stewarded by the Chief Justice. The judiciary in Kenya had never been independent. It supported colonial rule. It supported the white settlers against Indian traders and against African laborers. Suddenly, it was required to turn a 360 degree and do something different. This is what I'm calling the difference between political reality and political idealism. That's why people say South Africa has the best constitution in the world. My question has always been, compared to what? Measured by what indicator? This is the one country in the world with the greatest differential of income and opportunity. How can you have the greatest constitution in the world that doesn't translate into the equality of human beings in terms of their economic well-being? That's why we need to go beyond what the letter, the black letter of the Constitution says, to where the Constitution lives. And that's what my book is about. Where is the Constitution? We have two constitutions at any given time. The Constitution with a big P, which is the paper. There shall be the Republic of Kenya, there shall be a National Assembly, there shall be Senate, etc. That's the Constitution with a big P. The Constitution with a small p is what happens around the big P. In this country, the Constitution has something we all call the two-third gender rule. Yeah, I worked so hard to try and find how we could fix it. I can tell you, I spent 7 years, I was unable to do it. I went to the Supreme Court, I got an advisory opinion, we came and drafted 4 different bills. To this day, it is not in place. So, is the Constitution dead? But is the Constitution speaking in one language, and are we acting a different way? Absolutely. So, those people who keep saying that the Constitution is absolutely clear, to my mind, don't understand the difference between stating the principle and applying the principle. Okay.
Thank you, Prof. Aisha, can I turn to you?
Yes, thank you. Actually, Prof has very irritatingly answered some of the questions I had for him. I had a very good question about how to design against failure, which I think you basically have answered by saying we can't really design the Constitution adequately. It has to arise in a more natural way for it to really be a living document. But I think there's something you said which I do want to just comment on or challenge you on, which is that there is a mismatch between our Constitution and our reality. But isn't that the point of an aspirational Constitution? That instead of saying we will wait until slavery is abolished in a natural economic form, we will state instead that slavery is unlawful. Isn't that the whole point of the Constitution, that you are aspirational and that you state what you intend to achieve rather than your current situation today? What would you say?
Well, the Constitution must be aspirational for many reasons, including that not every word in the Constitution is intended to be law. In fact, I like to give the example of the preamble, which I drafted myself with a few team members. Yeah, then it has those very lofty declarations, yeah, of who we are and how we see ourselves. Yeah, Kenya is a multi-party state, etc., etc. We united and so on and so forth, recognizing the valor of our ancestors as they fought against colonial domination. This is poetry, and it is good. And it is good. It is not intended to be the subject matter of litigation. So I think that you're quite right, that there are many things we say in our Constitution that are aspirational. We talk about one of the things that my administrative law teacher had warned me against many, many times, and now it has become commonplace, what we call public participation and public policy. The minute the court becomes an arbiter in public policy, then the court is making political choices. Now, if you want the court to make political choices, you must deal with the fact that judges are unelected. And whatever policy choices they may make may not sit well with the electors who have designated their members of parliament. Yeah, those ones we don't think highly of. But the public has said, this is the person who will go to the National Assembly and make the law. And a judge in the High Court says, oh, come on, why did they say this? We have had situations where a judge says, the Minister for Transport has gazetted a notice that says matatus should have 21 passengers, no less. The judge says, 21? No, 14 is reasonable. Is that an interpretation of law, or is that making policy? It's making policy, and it is dangerous beyond. Okay, a judge says, the minister says, the governor says, no nightclubs selling, playing loud music after 11. Judge says, oh, come on, 11 is a bit early. What? Let's put it 2. Is that judgment about law or about policy? Policy is a dangerous, dangerous battleground.
But I guess just to challenge you there, Prof, because we see this in the area of environmental law.
Yeah.
Is it valid for a judge to then say, well, we have a right in our constitution to a clean and healthy environment, and there should be a line after which you can't hear diamond platinum in your neighborhood. Okay? The diamond platinum must stop at a certain hour. Okay? So where is that line? To take your example, would it be legitimate on the grounds of protecting a constitutional environmental right for a judge to intervene?
The judge should intervene in accordance with the law. If Parliament has said a nightclub can only function up to midnight, the judge cannot second-guess the legislature. That is not his role. The judge can say citizens are entitled to a noise-free environment. It's in the Constitution. And Parliament has enacted a statute to enforce that. So what does that statute say? And the judge must stay with what the statute says.
Right. Okay. I think we have a question from the floor.
Yeah.
Can you hear me? Yes.
Okay. I'm Lulu from Strathmore, and my question is on the point that you just made, that a court should not, a court does not have the authority to go against what legislators have said. But isn't that the whole point of transformative constitutions? Given that our constitution is a transformative one, isn't the whole point of transformative constitutions to counter the nature of like our politics now, that maybe politicians might not make the best decisions, and that the courts are instead vested with that power to remedy some of the policies that they make? Isn't that why transformative constitutions are in place, especially in the global south, because of the dysfunction that exists within our political system?
I think of the Constitution the same way I think of free markets. No, sorry, I think of politics the same way I think of free markets. Politics left on its own would result in a situation where the mighty control the powerless, forever and in perpetuity. So why do we need the Constitution? To mitigate that might is right. The Constitution comes to bestow powers on minorities, protection on minorities and persons specially situated within society. In the area that my friend Karim Anjarwalla practices, they would like free markets, complete free markets. But we all know that free markets don't work. And that's why we have competition law, and we have competition authorities, and we have all manner of regulators to keep the capitalist, if one can ever achieve that, on the straight and narrow. I don't believe that one can, but as straight and narrow as possible. Now, let me come to your point. What does a transformative constitution do? It is, I think, to create inspiration for the society we can achieve. It cannot and should not redistribute power in a manner not anticipated by the Constitution. The judicature is an independent power, an important power, but it is not the only power. We have the legislature, we have the executive, and we have other pockets of power. So a judge who says, our Constitution is so transformative that everything the ministers do, I must have a look at it afresh and ask myself whether they have acted in accordance with the law. Of course, the legislature can overturn any statute that violates the Constitution. There is no question about that. But it is, in my opinion, a judicial overreach for judges to place themselves in circumstances in which they call almost every conceivable decision of other entities to be reviewed by the judiciary. And it is a recipe for disaster. In my very humble view, the judiciary commands respect, great respect, the greater it distances itself from politics and policy. The sooner the judiciary descends deeper and deeper into purely political questions, the place it sits at on the pedestal is compromised. I hope we have found a middle ground.
Thank
It seems that we may not yet have found a middle ground, but in the process of this hour, I'm sure that we will. Prof, I mean, it's interesting, isn't it? What Prof's response, I think, speaks to some very large fissures in judicial thinking around the role of the judge, right, in the constitutional making process. And these are very important debates. You see the echoes of that debate even in the United States now, in the way that their constitution is being interpreted. And so it's very important that we continue this discussion around the correct role of the judge. But I think we can all agree that if the arms of government each overreach into each other, that is a recipe for chaos.
Absolutely.
Right? I think we can all agree that. We may disagree on what an overreach is, but we do need to agree that overreach in itself is a recipe for chaos. Prof, I want to move the discussion on a little bit, if I may, and talk about the role of the AG in the constitutional process. Under Article 156 of our Constitution, the AG, of course, I was about to say you, and I had to correct myself. The AG is the principal legal advisor, of course, to the government and represents the government in proceedings. And under 156.6, you have the AG has a duty to protect and uphold the rule of law and defend the public interest. Past experience tells us that these duties can appear, or in fact could be, contradictory. Okay? So my question to you is, do you agree with that? And when you were the AG, how did you think about balancing competing interests?
Well, let me start by saying that in the Commonwealth tradition of which we are inheritors, the Attorney General is actually a politician. And he is appointed by the winning party, by the ruling party. Just like the Prime Minister appoints his ministers, he appoints the Attorney General. You must have seen that in the UK a few weeks ago when our Kenyan Prime Minister, Mr. Sunak, I think we are populating the world with leaders. And I think that is a testament to that. A question I didn't answer, are we succeeding in our search of nationhood? I think we are doing quite well. Sent a president to America, now we've sent a prime minister to the United Kingdom. Now, precisely because the Attorney General is a politician in the British tradition, there are three law officers: the Attorney General, the Solicitor General, and the DPP. They are called the law officers of the Crown. The Attorney General, therefore, has a dalliance. He has a dalliance with the politicians. In fact, I remember when we were in Bomas, the reason we separated the DPP from the Attorney General is we said the independence of the Attorney General is compromised by him sitting in Parliament, then sitting in the cabinet, then sitting in Sharia House. And we said we want to insulate the DPP from the politicians, so they have no excuse to go and knock at the DPP's office and so on and so forth. So I'm the first to admit that there is a historical tension. Now, in the United States, it's even worse, because the president appoints his attorney general from his own political party, and America has become so politicized that just like the president tries to ensure that judges getting to the Supreme Court largely agree with his view of the world, the Attorney General also in the United States is brought in on the basis that he shares the vision of the president. So much so that, that President Kennedy brought his own brother. It can't get any more nepotistic than that. Now, but there is that tension is mitigated by the fact that the attorney must act in the best tradition of the bar and of the profession. And even when you get a man like Sossion, who was Trump's first attorney general, and with whom they were so ideologically married, they didn't stay for long, for obvious reasons, because as a jurist, there is a modicum of integrity that must be consistent with what you do, what you say, and what you advise. And even the last Attorney General to Trump, who was coming in for the second round.
William Barr.
Yeah, William Barr, whose book I've just finished reading. He writes a very self-serving account of his time there. Says, I told them all the right things. They didn't listen. Even he, towards the very end, you remember when the invasion of the Capitol was taking place after the election, he's busy telling Trump, no. There is a place where we must stop. So, my own experience, I think that I never had a situation where any person suggested to me what the law was. And I think that there is a sense in which that is also one's force of personality, if you wish, or one's commitment or fidelity, if you wish. But I never found anybody who came to me and said, shouldn't the law say this? I did witness in countries not far away from here, meetings in which I attended, in which the president was the one declaring the law. And not used to it here at home, I very quickly suggested to the gentleman that, Mr. President, I do not think that is what the law says. And I could see the shock. So I think that it is a factor of many things. It is a factor of what the executive itself is willing to allow itself to be guided by, and also the personality of the individuals in those institutions. And but I'm the first to admit that tension does exist. And in many situations, even very, very distinguished lawyers massage the opinion so that it may not be so diametrically opposed to the prevailing political reasoning. And a good example is Lord Gladstone, I think it was. Is it Goldstone? I think it was. On the invasion, yeah? Goldsmith, on the invasion of Iraq. And he wrote a legal opinion on the international law, legality of the invasion of Iraq, that all serious lawyers today would take with a pinch of salt.
And the same, of course, is true of judges, right? They can also, in certain instances, be prevailed in the public interest now to view. So, for example, in the United Kingdom, you had the Supreme Court turning a blind eye on admitted corruption in defense contracts because certain foreign governments said they would withhold cooperation in the field of intelligence if that corruption was further investigated. And the judges in that case held that the prevailing interest was in hiding corruption, and that overrode there was a greater public interest in defense. So I guess that infection of politics can apply to the AG's role as it can to judges.
And I think you can read in your own time the Supreme Court decision on Pinochet's extradition. And I think it's an excellent example of how the court tries to read the mood of politics.
So, Prof, moving on then, in your book you discuss the failure of the so-called WACO draft. Right? And November 2005, I think 58% of us voted against the constitution, the proposed constitution. And you talk about the perceived political winners and losers out of that contest. And of course, 5 years later was born the 2010, the current constitution. More recently, we've seen the failure of the BBI process led by the outgoing president and Honorable Raila Odinga. Looking back, would it have made a difference if WACO had actively, as AG, fronted the draft? Should he have fronted the draft? The BBI process, could it have been more tethered to an Attorney General-led process? Would that have made a difference?
Well, I think we need to remind ourselves where this struggle for a new constitution came from. It's very old. We started actually with trying to democratize. We were not talking about a new constitution, but post the creation of a de jure one-party state in 1981, I believe it was. Then we went into a dark 10 years in which the democratic state space shrunk so substantially that we were just gasping for air, and we were talking about very short steps. We were saying we must stop detention without trial. And that, in those days, was such a huge demand. It was such a huge demand in the context of the politics of the day, because detention without trial takes us back to the administrative state and the way it overreached into post-colonial Kenya. So when that little window was opened and the whole question of detention without trial was sort of resolved, it was resolved. Then a bold claim was made by those who were active in this space. Now they said, no. This de jure one-party state has to go. We need multipartyism. And then we went to that. And then the multipartyism issue, it kept morphing. And then we got to a space where now we said, no elections without a new constitution. And then we fought over that for a long time. And President Moi finally gave in and said, okay, you want a new let's have it. So by the time we created the Bomas process, we had been pushing at this rock for so many years, and it was moving very slowly. So by the time we got inside Bomas, civil society was more vocal, was more intellectually articulate, was more organized, was more prepared for the constitutional debate. The government was not. I remember as chairman of ICJ, we had already drafted what we called then the draft constitution. So we had a draft constitution. Kivutha Kibwana and his group had a draft constitution of their own. The government did not. So the government went into the constitutional making process that produced the Constitution 2010 on the back foot. All right? And what happened then was an attempt to claw back. But this attempt was interrupted by many things. There was the contested, by the time President Moi is leaving and the new government of President Kibaki is coming to office, we lost half of our civil society champions. They went into government, they went to become ministers and other important things. So again there, we were a little bit in. So this struggle has been a struggle that, that implicates too many things. So why does the WACO draft become necessary after we leave bombers? It's because the government now is reorganized. The government has reorganized and regrouped. And it is trying to, for lack of a better word, to water down some of the more radical provisions of the bombers draft. So I don't think there was an option for my predecessor. In fact, this now deals with what we've just discussed a few minutes ago. His brief from his political authorities were, this thing it's too radical in the wrong direction. Let's bring it back to the middle. That's why a lot of you had problems with it. I hope that explains.
Yeah, I think that's a wonderful explanation, and I think it also speaks to the power of the people, right? Because in 2005, a political class had put forward a constitution, as you say, clawing back many of the things that Burma and civil society had fought for, and was roundly rejected. So I think there is a glimmer there of something, and of course we then end up with 2010, which I think by any measure was an improvement on 2000 and not far from perfect, but an improvement on 2005. So in many ways worth the wait, and I think a testament to our political leaders of the time for having a second go at the same thing within the presidency of the same single president, 2 goes at a constitutional making process via referendum.
If I may interject, we arrived there again through a terrible, terrible tragedy that you must never forget, because the constitutional making momentum came to an end. It was ebbing until we had ethnic clashes and the real drama that drove our country to the precipice. So when we were pulling back from the abyss, restarting the constitutional making process became a condition precedent.
And is that, Prof, in a sense, to go back to what you said about the French, was that, at least in small measure, our revolutionary moment, right? Our looking at the precipice moment as a nation and as a country?
I would say so. I think that there is a sense in my generation, many times we were told, Kenya, Ivory Coast, these are very, very strong democracies on the African continent. They are not prone to coups and all that untidy business. Kenya went to the abyss, completely in the abyss. So did Ivory Coast. Kenya ended up at the ICC. So did Ivory Coast. So I think it was a defining moment that we could lose everything. And we must not take for granted the things that we have made over generations.
I think we have a question at the back before we turn back to Aisha.
Can you hear me? Okay. Yes. My name is Bettina Okinyi. I'm a trainee lawyer at Anjarwalla Khanna. Just going back to the point of civil societies, going back Going back to the point of civil societies, and you mentioned it in your book, how civil societies were key in constitutional reform. And now coming back to the present situation where it's like the voice of the civil societies is dying down and the political class, let's say political elites, their voices are overshadowing the voice of the civil societies. And in this case, we can look at, it's like this political class is taking up constitutional reform, and in this case, BBI, for example. Is there a danger to that the civil societies have gone up? Or, for example, how the leaders of civil societies went into government? Is there a danger in that we might have a shortage of heroes and we might create hard times going forward?
Well, I think I'd have to agree with you that the momentum for constitutional change, when driven by the political elite, is usually in the direction of either making it easier to govern without the constraints of democratic institutions or independent authority. And that's the momentum. If you look at the constitutional changes since 1964 to roughly about 1969, it's very quickly a concentration of power and authority, an emasculation of autonomous institutions, and the creation of an imperial presidency and the concomitant instruments to facilitate it. So that civil society brings to bear in the process what I would call the altruistic element, where you're not saying, create a seat so that I may come and sit on it. You are saying, looking at the way we govern ourselves. Take a debate that's going on right now, and I think it's very healthy. Should we have the leader of the opposition in the National Assembly? That is a very good debate, as long as the person driving it is not saying, create it quickly so that I come and sit on it. Yeah, and that's the difference between, and when I say civil society, I include the church. The church, the imams, the mullahs, and the cardinals, and whatever, they played a very vital position because they were one constituency that the politicians could not shout down. Or even if they tried, they would still come up. And, again, and talking of culture and ethos and values, Kenya is a notoriously religious country. No leader whatsoever will ever stand up and say, what? What church? What Kadi? What cathedral? Never, ever. Not in our lifetimes. So the church, therefore, enjoyed this sort of immunity from the brutality of the state, and therefore was able to bring up really very, very important pressure to bear. So I concede the point you make, that unless we have a new generation of civil society energizing the independent oversight over the political actors, then we will never have a vibrant democracy. And this is why even trade unions are an important part of that dialogue. And you have many other student unions, and so on and so forth. They are part of how you safeguard democracy.
Is there another question?
We have a lady here.
Angie, there's one.
Hello.
Yeah.
Thank you. My name is Daniel Morakaru from Kenyatta University. And my question, I'd like to go back to the question my counterpart had asked. about the role of the judiciary in monitoring the political class. And from the historical concept of our constitutional making, you have highlighted that we had scenarios where the political class was acting in an arbitrary manner and acting in a way that wasn't pleasant to the people. So isn't the judiciary coming in as a watchdog or as an entity to prevent a situation whereby we as Kenyans do not go back to the place where we were in, back into our history? So isn't the judiciary really playing a pivotal role when it goes and actually interferes with the policies that are made by the executive or the legislature?
In the interest of time, Prof, before you answer that, is there another question in front? Could you ask it, and then maybe, Prof, you can address both? Thank you. I'm just conscious of time.
Hello.
There's one here.
So it's important to mention that we are also live on different social media platforms. So we have chosen one question from social media. We are live on YouTube, we are live on LinkedIn, and we are live on Zoom. So based on this, we have chosen the following question related to rule of law. A key theme of today's discussion is the rule of law and how we should aspire to it. However, over the past few years, we have seen it steadily decline with court orders being selectively adhered to. To what extent do you feel the reason we have failed to adopt the rule of law across board is due to the absence of a connection between these constitutions as we know them and the history of African personhood?
Thank you. Prof, those are now two questions for you to address, and there's a third in front here.
Yes, good.
Please stand up.
The Kenyan Constitution, like many other African constitutions, are not living constitutions. Or in other words, they are constitutions without constitutionalism. Being a present issue in many African jurisdictions, what then do you recommend that we upcoming African lawyers should do to apply the Kenyan Constitution to reflect its transformative nature? Thank you.
These are wonderful questions, and I'm being told, but I can't read it. How many minutes do we have left? 10 minutes. Wonderful.
Okay, let me take the last question. I don't think it's true that there isn't a living constitution in Kenya. This is one of the first countries in the world, not in Africa, where a presidential election has been upset by the court. How can you then say that that constitution is dead? We have a judiciary that routinely challenges even the presidency, not to mention revokes several laws for. So I think that if you hit Kenya with the same stick as many of our neighbors, I think it would not be fair, because we've really come a long way. I bumped into somebody the other day who told me that they were watching the presidential petition all the way from China. I was in an arbitration with an American man who told me he was glued on the presentations and so on and so forth. So I think Kenya is a leader in many ways. And which brings me, however, this is a work in progress. There is so much more we can do. And this brings me to the question of the obedience of court orders. I think that is fundamental. It is so fundamental to the rule of law. And it is something that requires attention by the executive. And this is where we were saying the executive cannot ignore the existence of parliament, nor can it ignore the existence of the judiciary. And until a court order is overturned, it is binding on all institutions of state. And here, I think all of you have touched the soft underbelly of the beast. This is something that does require attention. and a commitment. Because the more, every time you disobey a court order, you bring the whole of law into disrepute, including the statutes that you are making in Parliament, including the gazette notices that you are issuing, and so on. So that it is in the interest of all of us to have obedience to the law. But this gives me an opportunity to speak again to the question of the judicature. And I think I didn't make myself clear, because the gentleman who asked this question suggested that I have been saying that the judiciary should leave politicians alone to do what they want. Nothing could be further from the truth. What I have been saying consistently, it is the work of the judiciary within the Constitution and the law, not within personal opinion. The greatest claim that our law makes, our profession makes, is that we are independent, we are neutral, we are value-free, and we are objective. That is why the subjectivity of an individual judge cannot be permitted to become the hallmark of the jurisprudence. Are we together? That is to say, if we allow a judge to pronounce his own political opinion, his own view about morals, if a judge were to start by saying, I am a Catholic, I find the arguments made before me to be totally ridiculous and abhorrent. How would that sit? Or a man who would start by saying, I am from this community or that community. The right of a man to be polygamous can never be questioned. I wonder how this suit was ever filed in the first place. What kind of judiciary would that be? What we are saying is that the judge must start all his inquiries by saying, the issue be brought before me for resolution is this. How should the adoption of a child born out of wedlock be done under the law of Kenya? I turn first to the Constitution. Then I turn secondly to the adoption law. Then I turn thirdly to the jurisprudence that has emerged on the protection of children. Now that is a judge. Are we together? That is all I was saying. I was not saying that the judge should say, oh, the persons before me are politicians, they wield enormous power in Kenya and indeed on the African continent, and my hands are tied. That's what I'm calling policy, political speech, whatever. That is what we don't want to see within the judiciary.
Wonderful.
I think I've finished that.
Absolutely, wonderful. I think we have 5 minutes left. Aisha, over to you, and then we can wrap it up. We could go on for hours, I know, but unfortunately time is limited.
Thank you, Professor Githu. You've touched on a number of things, but I think we come back to my original question, which was how do you design a constitution against failure? And you define failure in your book as not getting widespread acceptance from the general public and also not sufficiently accommodating the political elite. So that if you don't do both of those things, one or two or both of those groups will ensure that your constitution does not last. Taking everything you have said about where we are in Kenya, the fact that we have a lot of paper and maybe fewer living rights, what could you propose for the incoming Attorney General in terms of how do we together, or how does the Attorney General fulfill his constitutional duty of upholding and protecting the rule of law, and in particular defending the public interest? What would you suggest? Because you've been there, you've done it, you're now on the outside, and we are actually, if you ask me, at a really critical point where we could improve or, in many ways, allow the politicians to drag us back to the dark days?
Well, first, let me say that I cannot presume to advise the Honorable the Attorney General. In this particular situation, he was 2 classes ahead of me. He's my senior, so it would be exceedingly presumptuous. However, I would agree with your assertion that the stability of the constitutional order depends on the stability of the political order. There is a direct symbiotic relationship. Once you have an unstable political order, you cannot have a stable constitutional system. That is why it is so important that we have the independence and interdependence of the arms of government. The executive must respect the judiciary must respect parliament, and as long as we are not overreaching, that's why an overreach is very disastrous, because an overreach destabilizes the constitutional harmony. If judges daily are issuing judgments, running ministries, you can see how an impetus to ignore the order can be generated. So there is judicial restraint, and judicial restraint is not a dirty word. It's actually a well-accepted constitutional principle. The judiciary must restrain itself from pronouncing itself on matters of a purely political character. Parliament must restrain itself from legislating willy-nilly. It must remain constrained within the Constitution and the law. The executive must exercise authority within the limits of law. Which brings me now to society and community. Law must have legitimacy. Law has legitimacy because it is perceived by those it regulates to be reasonable, to be fair, to be in the public interest, and to be in the national interest. If those that law regulates begin to feel that law is opportunistic, self-serving, in favor of a group or a section, it has no legitimacy and there is no obedience to it. Nobody feels I need to obey law. After all, we know why the law was made. When I was in first year, we were very clear. It was to protect the capitalists and their...
Why he looks at me at this point, I have no idea.
And their joyriders. Now that I'm old and gray, I have shifted from that view, and therefore Karim is safe in my company. Yeah, thank you.
So I think that's a great answer, and I think it speaks to, I can't remember who in the audience said it, but the difference between a constitution and constitutionalism, right? What Professor Githu is saying is that this restraint, the ability for a minister to accept the outcome of a judicial result, is part of constitutionalism, right? And indeed, if our politicians could understand how powerful it is in their own interest for them to be seen to be accepting a court order, in a broader view, the investing community, the global community would look at a nation with much more respect if they saw the different arms of government behaving themselves, if I can put it that way. I think Angelica is sort of begging me for one more question. Before I do that, just give me 1 minute. I want to end in a slightly optimistic note in terms of what we said, because we discussed, didn't we, earlier, Professor, that by 1969, the Kenyatta government had effectively dismembered the Lancaster House Constitution. Within 6 years, it effectively had been dismembered, with a number of changes starting, I think, as early as 1964. Months after we had enacted the Constitution. We are now 12 years into the new Constitution, and somehow we haven't had a single constitutional amendment. And I think that changing constitutions slowly, as a general rule, is better than changing them quickly. I'll take the question at the back, which is now moved to the front.
Of your former students at the School of Law, at the law school, Parklands.
I remember.
Yes, and now a director here at Anjarwalla Khanna. Perhaps as you close, just some reflection. I was one of those who used to enjoy watching your submissions during all these petitions, particularly on the BBI. You had a very interesting observation you made that one side, was making submissions based on law, and that your observation was that the other side was actually making submissions on law as it ought to be, so that, and in the end, we know how sort of the situation panned out. Those who advocated for the law as is, sort of their positions seem to have been shunted aside, and it seemed to have the actualism, all this idea, the idealism of what the Constitution, how it should be managed, seem to have carried the day. Do you have any particular observations or about how judicial activism is sort of playing a role, in a sense, in the way law is being fashioned? Now, not as is, but as it seems like there's sort of some notion of where it should be heading. Thank you.
Yeah, in my earlier writings, when I was a young teacher, researching constitutional law and writing about it, I lamented several times in several articles the failure of the judiciary in Kenya at the time to deploy a more liberal jurisprudence. For many years, that was my theme. And I was shocked in my own lifetime when I was overtaken by another group that ran away with the idea not only of a liberal approach, but an ultra-liberal approach. And I got very alarmed, and I have been returning to the center myself, because I saw the danger of the radicalism of the left as equally as the radicalism of the right. And to my own mind, this jargon about the law, the spirit of the law, my own argument always is, when you write a lease, when you read a lease, the tenant and the landlord, do you first gather the spirit of the lease? Or do you go to the lease and read it? This lease is for a period of 1 year. How do you infuse a little spirit there? Now, a man or a woman has written a will to my daughter Anne-Marie, my Rolex watch. Now, at that point that you are reading the will, where will you gather the spirit of the will? To my own mind, in my own experience now, as an academic and as a practitioner, the first place you go to find the law is within the law itself. And only the very, very weak lawyers who have not looked at the law start by telling the court, now, Your Honor, generally speaking, the law has no generality. The law is specific. So to my mind, there is a place for a judiciary that moves with the times, and we don't need to change the law all the time. And the American Constitution is a good example. It has grown over time, not by a new statute being made all the time. We can expand what we are reading into the law. There is enough in the law that allows us to have a more robust interpretation. Okay? An interpretation that ensures if gender is implicated, that one is sensitive to gender. if race is implicated, if religion is implicated, you can have a dynamic. But I do not believe that it can be legitimate in a liberal democratic constitutional order for judges to read their own prejudices, their own inarticulate premises into the law. That should never happen, and it is as dangerous as if some radical in the National Assembly is legislating his personal choices to govern the entire society. Thank you.
I was reminded, as Prof was speaking, I was in Uganda some years ago in the High Court, and the issue was whether the other side had acted in contempt of a court order, which we clearly said that they had. And the lawyer appearing before the judge said, Your Honor, the spirit of your order. And the judge flicked through the court file, put his glasses down, looked up, and said, Mr., I'll leave the name blank because you know him well. Mr., tell me, pray, where can I find the spirit? Well, look, we could go on and on and on, but we have run out of time. Professor Muigai, it is an absolute honor and privilege to have had you with us. I know that we have all learned a lot, we've laughed a bit, and we've left much more educated about the process of constitution making and what we might do in the years ahead to protect the many gains that you have quite rightly pointed out we have made over these several years. We are most grateful that you've taken time. We know how busy you are. We are most grateful you've taken time to be with us. And please join Aisha and I in giving Professor Muigai a big round of applause.
Thank you.
Thank you. The books are outside. Professor Muigai will stay with us for about 20 minutes. And so please make your way out and we can mingle upstairs. Thank you all.
Okay, thank you.